What do we do when the defense has you examined by a doctor of their choosing and the doctor writes a report that basically says your injuries are not as bad as you claim them to be? What do we do in that instance? You want to know what we do? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. I'll tell you what we do. We go ahead and we underline carefully that report. We go ahead and we identify exactly what problems and what deficiencies the doctor left out of your report. We identify how the doctor came to the conclusion and how he reached his opinions about the fact that your injuries are nowhere near as bad as we claim them to be. That's what we do. And then we wait till trial. In addition to that, we also do some other stuff. We will go ahead and try and dig up some dirt on the doctor who has examined you. Let me go back for a second. When you bring a lawsuit, whether it's a personal injury action, a medical malpractice action, or some sort of accident, and now you go ahead and sue the people who you believe caused you harm and injury, during the course of your lawsuit, the defense will have an opportunity to go ahead and have you examined by a doctor of their choosing. In some instances, the injuries are so obvious that they know going ahead and having a doctor examine you is not going to be fruitful for them. So in that instance, they will waive their right to go ahead and have you physically examined. However, there are many instances where they turn around and say, you know what? We are going to have you sent, you the injured person, the injured victim, the injured patient, we're going to have you seen and examined by a doctor of our choosing. Maybe they send you to a neurologist. Maybe they send you to an orthopedist. There could be many different specialties in which they want to send you to get evaluated. But you should know something really important. The purpose of you going to this physical examination has nothing whatsoever to do with another doctor trying to help improve your medical condition. Nothing. The whole purpose of setting up this type of examination is solely for medical legal purposes, so that the doctor can evaluate your current condition, review your medical records, listen to whatever complaints you have today, and then draft a report that is almost always favorable for the defense. So you might be thinking, how can they do that? How are they allowed to do that? I'll tell you how. It's because when you bring a lawsuit seeking money as a form of compensation for all the harms and losses and damages you incur, the defense doesn't truly know whether or not our injuries are really as bad as we claim them to be. All they know is they have copies of your medical records. They have testimony that you have given in this case where you have now answered questions from the defense lawyer about all of your injuries. Now, what do they want to do? They want to verify that your injuries are in fact serious. They want to verify that you have permanent and disabling injuries. So one of the key ways that they will do that is by hiring a doctor to go ahead and have you examined. One of the things you will notice is that when you go in for your examination, many times, not always, but many times, the doctor spends very little time learning your history. The doctor often spends very little time identifying what problems you have today and simply relies on the information you filled out on a particular form. So this doctor is not there for the purposes of treating you. This doctor is not there to try and help you get better. Rather, their goal and the doctor's goal is to try and minimize whatever injuries you have. So once the doctor has gone ahead, evaluated you, and now prepared a report and send it off to the defense attorneys, the defense has an obligation to share that report with us. Now we know that this doctor will likely be coming into trial to testify on the defense's behalf to try and minimize whatever injuries you claim to have. Okay, so how do we rebut those claims? I'll tell you how. Not just by cross-examination, but by bringing in your own treating medical doctors to show to the jury the extent of your injuries, to show to the jury how often you have had to go back to these doctors, your treating doctors, the doctors who are interested in trying to get you better. And now these doctors have come to the conclusion that yes, you do have serious physical injuries, and now they are permanently disabling. And then when the defense has the opportunity at trial, they will go ahead and bring in this examining doctor to do what? To basically try and minimize every single thing that your treating doctors have said. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I recognize you're likely watching this video because you wanted to see the beautiful scenery and the mountains behind me. No, that's not why you're watching it. You're watching it because you likely have questions about your matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.